Good morning, students. Myself, Prakash Raj Pandey, presenting here to discuss the subject matters relating to meaning and definition of law, nature and characteristics of law, types of law, and also the meaning and sources of business law. However, I am discussing the subject matters at the same time. I am also wishing you people starting to subscribe, share, and like the videos. Keep watching. Thanking you. SMN Station Mission Education. SMN Station Mission Education. SMN Station Mission Education. Now we are going to discuss about the law. Meaning of law. The term of law means a set of rules. The rules are made by authorities to reform the conduct of man. Thus, Ashton says, law is the command of sovereign authority. Law is an English word derived from the Stoic term lag. It means stable or universal. In general sense, law is the command of the state to manage or regulate the external human activity. Law is that which must be obeyed and followed by citizens subject to sanction or legal consequences. Law is as old as human civilization, hence it is the oldest discipline of social science and is the outcome of the human society. It is a rule made by authority for the proper regulation of a community or society for correct conduct in life. Then, what is the definition of law? According to the Hindu religion text Vedas, law is the king of kings, or more powerful and rigid than them. Nothing can be mightier than law. This Hindu text gives more emphasis about the definition of law. It put into the superior than other things. Similarly, Salman says law is not rigid alone, might alone, but is a perfect combination between the two. John Austin says law is the command which obligates a person or persons to a course of conduct, and Holland says a law is the general rule of external action enforced by a sovereign political authority. T.H. Green also gives the definition about the law that law is the system of rights and obligations which the state enforces. Lawrence, Robert, and Peter also says the law refers to the body of philosophy, principles, standards, and rules which the court apply in deciding cases brought before them. About the meaning, Black Law Dictionary also says that law in its more general and comprehensive sense signifies a rule of action and is applied indiscriminately to all kinds of action, whether animate or inanimate, rational or irrational. To summing up about the law from the above mentioned definition, that law is the system of rules of conduct established by sovereign government or society to correct the wrong and maintain the stability through delivery of justice. Now, we are going to discuss about the nature of law. Law is the comprehensive devices of establishing and maintaining social order. It is also a mechanism of social control. By observing the above mentioned definition, we can find out the following points regarding the nature of law. Law is enacted by sovereign authority. Law is the set of rules of conduct of society. Law regulates the external human behavior. Law has uniformity in action. Law is the most powerful in the world. Law helps people to live in peaceful environment. Law stops and protects people from going to the worst way. Law is the combination of rights, duties, and power. Law is inevitable to develop society. Law and justice are interrelated. Law is administered by court. Okay, from the nature of this above mentioned things, the characteristics of law can be of equal treatment. Law treats equally. It never discriminates the subject on the basis of sex, race, language, and religion. And it is also the means for justice. Justice is always provided by law. Without law, justice cannot be imagined. Law aimed at peace. Law is made for keeping peace and developing society, the country through security and peace maintaining. And it is compulsory execution. Law always preserves the rights of the people who equally or regularly follow it and punish those who break it. Law is applied by the sovereign authority. The application and implementation of the law is vested on the sovereign authority, that is legitimate force. Law is administered through the court. The administration of law is delivered to the independent and competent court of law. It has the supreme nature. Law is supreme in its nature. In the system of rule of law, it is said that law is the king of kings and nothing is mightier than law. Recognition. The custom, precedent, ordinance, and orders of the government are recognized by the legislature in legitimate manner. Inevitable. Law is the means which can regulate and manage the humanitarian activities and organization, so it is essential. Law is also dynamic. It is not static. It is flexible in nature. It is changed in accordance with needs of society. Okay, now we are going to discuss about the types of law. Regarding the types of law, Salmon, the prominent author of the law, categorized into the following heads. Number 1, imperative law. Imperative law is a law which is enforced in the form of command. Salmon defined it as a preceptor rule of action imposed upon man by some authority which enforce obedience to it. The memorandum of association of a company, the statutory law, and international law are the example of imperative law. Number 2, physical law. It is related to natural law, so no one can breach this law. It is applied equally throughout the world like a civil and imperative law. This law is not created in regions even of particular country, as for example, law of gravitation and law of light. Moral law. Moral law is also known as natural law, which deals with the external activities and behavior of human beings. According to Salmon, this law deals with the natural justice and principles. Somebody likes to call it as divine law, since it is the command of God imposed upon man. It is said the law of ethics, law of reason, and universal law is the example of moral law. Conventional law. Conventional law has its source in the agreement of the parties. The parties involved in an agreement will have promised to do something for each other so far as the regulation of conduct of the parties is concerned. Their contract assumes the form of law. For example, the partnership deed is the conventional law. Customary law. The law derived from religion, tradition, and custom is called customary law. It determines the rules relating to the conduct and behavior of human beings according to Salman by customary law. Here we mean any rule of action which is actually observed by men, any rule which is the expression of some actual uniformity of voluntary action. Similarly, the customary law is not followed at the same manner throughout the country by the people. It is tribe, caste, language, and religion based. As a result, different type of customary laws are followed differently in different regions, even of a particular country. Next, practical law or technical law. Law made for attaining the practical end of a man is called practical law. According to Salman, some specific rules are needed to achieve objectives perfectly. This rule guides in attaining our purpose. For example, rules relating any art or business, the laws of health, laws of music, laws of story writing, etc. are the practical law. Next, international law. It refers to the collection of rules made by sovereign states for regulating their mutual feelings. According to Salman, international law refers to the rules made by sovereign states for their mutual relationship and dealing with each other. According to Oppenheim, it is the name given for the body of customary and conventional rules which are considered legally binding by civilized states in their intercourse with each other. Civil law. Civil law refers to all those laws which are enforced by the state within the territory of the country. It is studied as the main law. In the jurisprudence, Austin and Holland prefer to call it as positive law. Salman said it as law of state or law of land or law of the lawyers and law of court. Many others say it as local or municipal law. It is made by the state and enforced by judicial tribunals through physical force of the country. All civil and criminal law. Similarly, business law is also the part of civil law. The type of law can be discussed on the basis of different points of view. From the point of view of creation and nature of law, it is substantive law and procedural law. From the point of view of jurisdiction, which includes criminal and civil law, and from the point of view of legal effects, that is private and public law. Now we are going to discuss about the substantive law and procedural law. Any law has two-fold nature, that is substantive and procedural. They have a close relationship with each other. W. Cook is the first writer who distinguished them within law in his book entitled The Concept of Law. Substantive law gives knowledge about the people's right, whereas procedural law gives knowledge about the legal procedure that an individual can exercise to achieve such rights. If he loses them, the purpose of substantive law is to ascertain the way how to sue the other in the court and how the court is supposed to decide things in civil and criminal proceeding. Now we are going to discuss the differences between substantive law and procedural law. Okay. Substantive law is the law of rights and power, whereas procedural law is the remedies law. Substantive law is the end of the law and procedural law is the means of law. Substantive law explains all the law except procedural law, and procedural law explains only procedural law. Substantive law contains right and remedies of victim parties. Procedural law contains mood and condition to restore rights. Substantive law determines right and relationship of the parties of a case, and procedural law determines the relationship between the court and parties to a case. Substantive law is prescriptive. That means not influenced by retrospective events, but procedural law is influenced by retrospective events. And substantive law is ideal in nature, but procedural law is behavior in nature. Okay, now source of law. What is the source of law? There is the different opinions and views regarding the source of law. Somebody thinks the authority is main source of law, and other persons think the causes from where the law is derived. Many others argue that the source of law is the nature and types of laws as well as the institution enforcing such law. Even though we should clear about the source of law from the opinion of prominent scholars like Austin and Holland. According to Austin, the source of laws can be divided into three following sources. Number one, direct and indirect authors. Direct and immediate authors, it is such source of laws which include those person and group of persons from where the law is directly derived. From the point of view, there is four sources of law. That is, head of legislative or judicial body, head of legislative or executive body, that is politicians, and person conducting behavior from which the custom and traditions are derived, and persons who behave according to the agreement between the parties. And number two, historical document. There are the literary source of law which help to produce laws in the past in England, as for example, Digest and Code of Conduct of Justinian in Rome, and writing of Bacon, Coke and Littleton are universally taken as the source of laws. Number three, causes. Religion, customs, equity, good conscience, legislation, and adjudications are the causes of the origin of the laws. According to Holland, there are four types of source of law: the statute book, the report of the esteemed treaties and commentaries from where the knowledge of law can be obtained, the sovereign state which gives force to law, the religion and custom through which law is originated, and the legislation, the judicial decision, equity, etc., which creates new law. According to Salmon, the source of laws can be discussed into two categories, that is, historical sources and legal sources. According to historical sources, it includes the legal history only, but not to the legal theory. Therefore, the judicial decision made by courts at different times can be taken as one of the historical sources of law. Similarly, legal sources. There are the authoritative sources of law. For example, law made by statutes, judgment of the court, and contract between parties are the legal source of the law. Hence, legislation, precedents, customary law, and conventional law are the four sources of laws come under legal sources. Concept and importance of business law. The term business law means that branch of which comprises law concerning trade, industry, and commerce. It is an ever-growing branch of law with changing circumstances of trade and commerce. Hence, business law is defined as that part of law which regulates and manages all the transactions of business community, as for example, Law of Contract, Sales of Goods Act, Negotiable Instrument, Agency Act, Banking Act, Insurance Act, and the Law of Indemnity and Guarantee, bailment, pledge, carriers, and so on are included under business or commercial or mercantile law. Business laws also include the rules relating to formulation and dissolution of different form of business organizations like sole trading concern, partnership firm, joint stock company, cooperative societies, multi-purpose organization, and multi multi and so on. Definition of business law. Rosenberg and Whitcraft says that the real purpose of law is to help you get along with other people with business and social relationships. The term mercantile law is also used to denote aggregate body of those legal rules which are connected with the trade, industry, and commerce, says the N.D. Couple. Hence, legal rules and principles bearing on business organization and commercial matter is called business law. It regulates various forms of legal business entities, including sole proprietor, partnership, registered companies with limited liability, agents and multinational companies, corporation, nearly all statutory rules governing business organizations are intended to protect creditors or investors. In addition, specific bodies of law regulate commercial transactions, including the sale and carriage of goods. It means terms and conditions, specific performance, breach of contract, insurance, bill of lading. Then consumer credit agreement, that means letter of credit, loans, security, bankruptcy, and relation between employees and employer, which include wages, condition of work, health and safety, fringe benefit, and trade unions. It is a broad and continually evolving field. Then what will be the characteristic of the business law? Now we are going to discuss about the characteristics of business law. Business law is the law of business. Its nature is like the nature of general law. It is also made, enforced, and adjudicated by the competent authority. It is equally enforceable to all people based on common interest. In addition to this, it has some distinct characteristics which has been practiced in business. In Nepal, they can be of business law is related with establishing of business activities, agreement, transaction, settlement of disputes, and so on. Secondly, business law is related with rights, duties, and liability of businessmen. Thirdly, business law is related with regulatory body and business organization. Similarly, business law is related with national and international business relationship. Next, it is related with investment and business environment. And lastly, but not leastly, business law is related with business policies and people at large. Now, the importance of business law could be of the following. Deeper knowledge of law cannot be overemphasized. It is common knowledge that ignorance of law is not excused. That is why it is generally known as accepted, and every person is presumed to know the law. As such, it is indispensable for the people engaged in economic and commercial pursuits to gain themselves with the general principles of the basic business laws. Thus, the importance of business law can be discussed from the following points. Business law protects of economic rights of the business community. It regulates and systematizes the business. It is established and development for the better business sector, for the economic development, as well as business law enforce the business contract and business law delivery the justice related to the business community, and it emphasizes on social audit and responsibility. It achieves business goals promptly. So now we discuss about the process of business law, why it is important, where it is derived, or where from it comes. A source of business law means origin or sources or cause from where law is emanates. Business law may differ from country to country on the basis of social, political, economical, religion, culture, geographical situation. Regarding the leverage context, the source of business law can be discussed from the following diagram. Number 1, custom and uses. Number 2, statute. Number 3, judicial decision. Number 4, English mercantile laws. Number 5, commentaries, opinions, and logical expression of professionals and experts. Number 6, business treaties and agreement. Number 7, sales, company, agency, industry, arbitration, guarantee, indemnity, industrial law, contract law, insurance, banking, partnership deed, and law of carrier. Okay, now what about the custom and uses? The rules which is developed from the customs is called customary law. The law is binding to the community concerned. It is reasonable, ancient, and continuously followed for the number of years. It is recognized by the state which is not opposed to statute law, morality, and public welfare. In Nepal, trade customs are the source of business law in business law. Similarly, then what about the statute? The statutory law is made by parliament or legislature. It is outcome of demand of the people and the time. It is made by the lawmakers after discussing and debating in parliament. As for example, Arbitration Act 2025, Company Act 2063, Industrial Enterprise Act 2049, and so on are the statutory law in Nepal. Similarly, what about the judicial decision? Judicial decisions are known as precedents. Precedents refer to the decisions made by the judge of the final court in a given case on rational and equity basis. It fulfills the gap of law. Such decision is applied as law to other similar cases as the source of law and is followed by lower courts in giving verdicts in similar cases later. What about English mercantile law? England is the first country that codified the mercantile law in the world. Nepal and India are influenced in making business law by British rule since the hundreds of years. For example, common law, equity law, statute law, Roman law, and case law are the source of English mercantile law, which is so the case in Nepal. Now, commentaries, opinions, and logical expression of professionals and experts also the sources of business law in Nepal. The academicians and practitioners of law play the significant role in creating good legal environment. The commentaries, opinions, and logical expression made by such experts may give proper suggestion to the lawmakers. The judges also use the opinions of experts in course of issuing the verdict. Okay, then business treaties and agreement is also taken as the source of business law in Nepal. Bilateral and multilateral agreements between the nations and the conventions of business communities are the significant source of national and international business law. As for example, Nepal-India Transit Treaty and Nepal-India Trade Treaty is the source of business law in Nepal.
I would like to thank once again for watching this video and also requesting all of you to like, subscribe, share, switch on bell icon for more exclusive. The subscribe button and bell icon is just below. Keep watching. Don't forget, please subscribe, share and like for latest uploads.